Our next guest is the former president of the Law Society of Kenya, the 49th president of the Law Society of Kenya. He is now chairman of the Retirement Benefits Authority, the retired president, Nelson Havi. Good morning.
Good morning, Bart.
How is life in retirement? Paka, you even chairing Retirement Benefits Authority.
It is fantastic. It's awesome.
What does that mean?
It means it's good.
Uh-huh.
Well, the retirement you're talking about is not my retirement because I've never retired. I still have sufficient energy to work. Mm-hmm. But I'm chairing the Retirement Benefits Authority. It's a state corporation that takes care of the interest of us when we eventually are not able to work and want a comfortable life that is conducive,
right,
and commensurate to one's status as it when you're working.
It's the regulator for pensions.
It is the regulator for pensions, aptly put.
Very good. Now, there's a lot that's happening. We are not going to talk about pensions today. We'll talk about law, okay, and the justice sector, and what we've been seeing recently. Yesterday, the president, the Speaker of the National Assembly, the Chief Justice had a meeting. And out of it, they released a statement and said among the things that they've agreed, okay, which is going to support the judiciary in various things. We do not see any support that the executive will get from the judiciary or the legislature will get from the judiciary or from the executive. We just saw the support that the judiciary will receive from these other two institutions, budgets, particularly in budgets, and therefore helping them with that. Before that, the Law Society of Kenya, which you have headed previously, has been up in arms and saying, no. The Chief Justice and President of the Supreme Court should not be meeting with the President of the Republic. No, this is not a good thing. That's what we're going to discuss. Police plus other things that have been happening in the court. But to welcome you to the conversation, Buona City has the day's proverb. It's from the Kingdom of Morocco.
Yes, it is. Little and lasting is better than much and passing.
Little and lasting is better than much and passing. Nelson, what's your interpretation of it?
I think it's aptly put. You better consume it in little portions.
Okay.
Uma kidogo kidogo. Why?
Sababu ukiuma nyingi unaweza bebwa na maji.
Unaweza teuka.
Utaporomoka.
Measured everything. Okay. Yeah. So let's get into it. We are seeing this. Raila says judiciary could be compromised after President's State House talks with the CJ. Be courageous like Mutunga and Maraga, Orengo tells Koome after meeting Ruto. Independence questioned after Ruto Koome meet on corruption. The president of the Law Society says when the country has been tested, people have been reluctant to go to court because they feel even if they go, they'll not get justice. Senior counsel Dr. John Haminwa, the Chief Justice, and the president are not supposed to meet to discuss how things should be done. Lawyer Bobby Mkangi, who wrote the Constitution, in the dispensation of justice, you not only need to do justice, but justice must be seen to be done. Let's add Nelson Havi's quote. Go.
The background of this meeting is quite important. Who called for the meeting? It is the Chief Justice who called for the meeting. A fundamental mistake. Do we apportion blame on the part of the president? No. The president is an elected leader. It is his responsibility to be in charge of the nation. He's the head of state and he's the head of government. But as the head of the judiciary, it is imperative upon the Chief Justice to realize what are the parameters upon which she may engage with the other heads of the arms of government. But fundamentally, the outcome of this meeting speaks a lot. What the Chief Justice was asked to address was the wanton corruption in the judiciary. What did she go home with? She went home with her begging bowl full. 25 judges of the High Court, 11 judges of the Court of Appeal, and car loans. To what extent are these three issues going to help us fight corruption? Appropriately so, you said, the executive came out of this meeting with nothing. But that does not mean that we end there. It is incumbent upon the people of Kenya to ensure that there is accountability and independence of the judiciary. There can never be independence without accountability. So first and foremost, the Chief Justice must address the issue of corruption. Not because it was raised by the President, but because it is a big problem that has hindered the administration of justice in this country.
Does going to meet the President indicate in any way that the Chief Justice is not going to deal with corruption or is unwilling to deal with corruption?
No, it is an indicator that she understands that there is a problem. But it doesn't show us how she wants to address the problem. If she was keen on addressing the problem, she will have given us a roadmap, even without the call by the President, even without the demands by some of us in the legal fraternity. There are some of us who have taken to the streets protesting, saying that the independence of the judiciary is being interfered with. No, the independence of the judiciary is not interfered with. We have so far done so much to protect the independence of the judiciary. But what we want now is accountability. And it should not be that she's always woken up into action by third parties. It is incumbent upon her to ensure there is continuous progress in ensuring that every Kenyan has access to justice. Not justice that is available to the highest bidder, not justice that is encumbered by incompetence, delays in the delivery of judgments, days for hearing that are given 6 months, 2 years away from now. Those are hallmarks of incompetence and corruption. And these are issues that must be addressed by the Chief Justice.
So they needed to be addressed anyway.
Absolutely.
And there's work that needs to be done towards ridding the judiciary of corruption, and it's not going to be done in a day. But now with all of these things that are happening almost simultaneously, with the first call out from the President, the previous calling out of corruption in the or rather calling out of the judiciary on matters corruption, is justice on trial today in Kenya?
Yes, justice is on trial in Kenya today, and not at the behest of the big man, not at the lamentation of the small man, but on the complaint of everybody. And I must say this, and I'll keep on repeating. The main problem is twofold. One, there is corruption, a situation whereby we have judicial officers who take money to tilt the wheels of justice in favor of a party. And then the second aspect of it is incompetence, which may amount to gross misconduct. We have cases where you have judicial officers who do not render justice in good time, who do not give considered decisions, who do not give reasons as to why they have arrived at their decisions. And this has to be looked at it from that perspective. I have on numerous occasions suggested that we must have a permanent approach to scrutinizing how judicial officers work, with the vetting of judges and magistrates board. I do not know why our friends in the executive and the legislature do not want to take up this role now. We need the vetting of judges and magistrates to be taken at an interval. Some have suggested 5 years, some have suggested 10 years. I think 10 years would be an appropriate time. And I say so, bearing in mind that a judge serves for a period of 70 years. The judges who were recruited last year and the year before, some as young as 40, some as young as 38. We're going to have these people in office for almost 30 years, 40 years. How do we ensure that they are accountable? And if they are not accountable at intervals, then the problem that we've complained about is bound to persist longer than necessary.
But Nelson, they are constantly accountable in the fact that at any time, any person can raise an issue against a specific judicial officer, a judge, at any time. If you feel that a judge is corrupt today, you can take up that matter to the Judicial Service Commission and an investigation should commence immediately. If somebody else feels that the same judge is corrupt, tomorrow they can do the same. So throughout the tenure of a judge, they are accountable. Is that not so? Do we have to have a vetting? What does that vetting do that's different?
Look at the composition of the Judicial Service Commission as it is right now. Tremendous progress was made upon the promulgation of the Constitution, with the effect that the appointees then of the Judicial Service Commission of the President are not the case. The Judicial Service Commission is
They're a minority.
It's representative. It's representative of the legal fraternity. It is representative of the executive. It is a representative of the public.
Yeah.
But look at the Judicial Service Commission as it is right now. Are you confident that you can take your complaint to a Judicial Service Commission headed by the Chief Justice against a judge of the Supreme Court, against a judge of the High Court, against a judge of the Court of Appeal? There may be, and I speak this with a lot of information, there may be a lot of vested interests. That is the reason as to why we say the Judicial Service Commission as currently constituted is not competent enough. It does not have the capacity, the wherewithal of ridding this country of corruption.
Maybe just inform the public what the constitution of the Judicial Service Commission.
The Judicial Service Commission is comprised of, first, the Chief Justice,
Right.
a judge of the Supreme Court,
Yeah.
a judge of the Court of Appeal, and these two judges of the Court of Appeal and the Supreme Court, together with the judge of the High Court, are all elected. The Judicial Service Commission also has two representatives from the Law Society of Kenya,
Right.
one male and one female.
Right.
There is the Attorney General.
Right.
There are two members appointed by, actually 3 members appointed by the President
Right.
to represent the public. So, picking from that point, let me go back to the issue that I was addressing. The necessity to have a continuous vetting of judges and magistrates at intervals must exist parallel to the Judicial Service Commission. And I've said the reason as why it is proper to have this parallel mechanism is there are vested interests in the Judicial Service Commission that may require outside intervention and input for us to make progress. And look at the last 5 years. How many complaints against judges and magistrates have been submitted to the Judicial Service Commission and resulted in a recommendation for the formation of a tribunal? Very few.
Are we then imputing some nefarious activities? Because if indeed there were few, are we saying that the decision that was arrived at was wrong or was erroneous?
Which decision, Elder?
The decision not to have a tribunal, because I take the view that by the time an accusation or an issue reaches the Judicial Service Commission, whoever is taking it there has given it thought and they have evidence that they're going to provide before that particular group of individuals.
Okay.
Now, what I want to understand, Nelson, is what is it that makes them incompetent? What is it that makes them unable to fulfill the mandate that I think as a layperson, they ought to fulfill?
Now, I do not want to state that the decisions not to form tribunals when petitions are submitted to the Judicial Service Commission are erroneous. But it's a daunting, arduous task for you to remove a judge through the Judicial Service Commission. As I sit here, I have successfully removed a judge from office through the Judicial Service Commission at a very high cost.
What
at
cost?
A very high cost.
To yourself?
To myself. I was vilified. I was profiled. For about 5 years, I was not able to make progress before the High Court and the Court of Appeal. You will be targeted. You'll be identified. And look, if a distinguished advocate like Ahmed Nasir Abdullahi Senior Counsel can be isolated, identified, for an unlawful and constitutional punishment by the Chief Justice? What about those other mere mortals, John, Omondi, and Jerry, who are just about 2 years or 1 year in practice? I removed a judge at a high cost. That is the more reason as why we need a parallel environment where the public can bring complaints to be reviewed, to be analyzed, and the threshold is not the one that has currently been set by the Chief Justice, where often when you raise a complaint, you are told, no, the complaint borders on the decisional independence of a particular judge. The judge has made a decision. We cannot remove the judge because of that decision, because she or he is permitted to make a mistake within the confine of her decision making. But that is wrong. We've had judges removed because of the decisions they made. Take, for instance, Justice Murugi Mugo, who refused to give an advocate audience that was Zebedi Ongoya, and went further and decided to detain that advocate. She was removed from office for only that reason. One, she failed to give an advocate audience when the advocate appeared before her. And two, she decided to take the law onto her own hands by jailing the advocate who was before her representing a client's interest. And that is the reason why we need the vetting of judges and magistrates, not an institution that has a lot of vested interests in the name of the Judicial Service Commission, that is hell-bent in protecting
their own. So out of the 13 members of the JSC, 7 are judges.
Yes.
Okay. And then we have 3 lawyers. That includes 2 LSK plus the Attorney General.
And the Attorney General.
And the members of the public who may or may not be lawyers.
Yes.
Those 3. So you're saying that these 7 judges will more likely be acting in defense of their own.
Absolutely. Yes.
That's what you're saying.
Yes.
And, so
there's nothing wrong about
that.
So
we should make them not a majority in the JSC, but make them a minority in the JSC.
No.
Does that help?
The JSC, as currently constituted, is based upon what the Constitution has directed.
And is that what you're raising an issue with?
I don't have a problem with that.
Okay.
There is propriety in having a majority of lawyers and judges in the Judicial Service Commission, because they are better placed to understand the problems that bedevil the legal fraternity. But often, time and history may give individuals who hold office who do not know what their work is. You understand?
Mm-hmm.
Remember, at one point in time, we had 2 representatives in the Judicial Service Commission from the legal fraternity. The male representatives that I'm talking about, Ahmed Nasir Abdullahi and Professor Tom of Gender. These were individuals of gravitas. In fact, often you will think they were the chairs of this Judicial Service Commission. And they were impactful. And for good reason. Because they were there to protect the interests of both the judicial officers and of advocates. But history has the unfortunate outcome of giving you representatives who may not have that gravitas. I don't know whether you know the current male representatives of the male representative of the Law Society to the Judicial Service Commission.
He's the vice chair.
Do you know him?
We met the vice chair.
What is the name of the vice chair?
Masharia.
Masharia. Okay, fine. And as we go for this election of the male representative to the Judicial Service Commission.
Why were you asking that? You didn't know him?
Well, I wanted to know.
Like he's unknown. You feel as though he's unknown.
Do you feel him the same way you felt Ahmed Nasir Abdullahi or Tom Ogenda?
Actually,
we felt Ahmed Nasir because that's the time when judges are being interviewed for jobs.
Yes.
Beyond that,
well, during Ahmed Nasir's tenure, I believe there may have been about 2 or 3 recruitments. During Masharia Njeru's tenure, there have been about 4 recruitments. So the reason as to why you felt the impact of Ahmed Nasir Abdullahi is this. He came in at a point in time where the constitution had just been promulgated.
Yep.
We had the vetting of judges and magistrates.
Yep.
And we had several judges of the Court of Appeal being sent home
Yep.
because there was a concerted effort by the Law Society of Kenya to submit complaints before the board. And then at the same time, as the recruitment of judges started then, lawyers also submitted their views, appraisals, and complaints. And it's on the basis of that that you're able to see the impact of representation of the Law Society in the Judicial Service Commission. So going forward, it is imperative on the part of the lawyers to ensure that they have a representative who understands what his role is in the Judicial Service Commission. Somebody who will be able to call out corruption in the judiciary. Somebody who will be able to ensure that many of the appointees who end up being judges and magistrates are from the legal fraternity, practitioners, people who have gone to court, people who have an understanding of the court processes.
Nelson, I'm not sure I understand your line of argument here. You started by saying that the composition of the Judicial Service Commission hinders the proper vetting or removal of judges who are found to be corrupt, who are thought to be corrupt or felt to be corrupt by the public.
Yes.
So we asked about the composition, and we talked about the imbalance between judges and non-judges in the panel. And I asked you, so do you want to shift that balance? And you said, no, you don't have a problem with it. So what exactly is your issue? Are you saying that complaints against judges should not be taken to the Judicial Service Commission, should go to a different entity?
No, Latif, and let me make this clear for the benefit of those who are listening and watching. We have a Judicial Service Commission. Its composition is provided for by the Constitution. But often we'll end up having individuals in that commission, either as an outcome of an election or an appointment, who do not understand their work.
Yes.
We had a Chief Justice by the name Dr. William Mutunga. He understood his work. When you took a complaint to the Judicial Service Commission, it will be processed speedily and a judge will be asked to account. We had an individual who held the office of the chair of the Judicial Service Commission by the name David Kenani Maraga. He understood his work. We had a male representative to the Judicial Service Commission by the name Ahmed Nasir Abdullahi, by the name Tom Ojenda. We had a representative by the name Dr. Marcy Ndeche, who understood her work. So because we will have the unfortunate outcome of an election or appointment that will lead us to a perilous path as we are right now, it is imperative we have a parallel process. And it's not something that is coming out of the emptiness of imagination. It's been there before. We had it when we promulgated the Constitution. We had the Judicial Service Commission and we had the vetting of judges and magistrates. And it's only through that process that will ensure we're able to contain. We will never be able to eradicate corruption and incompetence. You understand? But we must contain it to an extent where justice will be delivered to our expectation.
Nelson Havi talking about corruption in the judiciary. Yesterday, the President, the Chief Justice, the Speaker of the National Assembly had a meeting, the outcome of which has been widely publicized. Well, many things that the Chief Justice went and presented there from what we see and what she came out of there with. First of all, commitment to increase funding for the judiciary so that we can hire more judges. Commitment to supporting the judiciary in its transport needs, and that is completion of the leasing agreements. But you're saying that she has not addressed the issues of corruption in the judiciary. And you feel that the judiciary needs to do more within itself to rid itself of corruption. You sat in the National Council on Administration of Justice, NCAJ, right? Representing
Yes, I did.
The Law Society of Kenya. This is the council that brings in all the stakeholders in the justice system. The Law Society, the judiciary itself, it brings in the court users, it brings in the civil society, brings in the executive, the police, the prosecutor, the DPP is there, and others. And the Attorney General, of course, is represented. This is one of the avenues that you had to say, you know what, we need to rid this institution of allegations of corruption, of the perception of corruption. And one of the things that we can do is go this route of maybe institute another radical surgery of the judiciary. Maybe every 5 years we have it, call it a vetting board, whatever you want to call it. Did you do that?
Eric,
Are there records of the NCAJ that would show that this is what the Law Society then proposed?
Eric, I'm battle-hardened. I'm a war hero.
Mm-hmm.
I've told you I sent a judge home at a very high cost. You see the wounds of this battle. When I served as president of the Law Society of Kenya, I was very pivotal. I was very vocal. When Uhuru Kenyatta refused to swear in judges, I didn't call for a protest. I didn't go begging anybody. I took the rightful action. I initiated the removal of the Attorney General and the Solicitor General. At one point in time, Uhuru Kenyatta kept on lamenting everywhere, like a headless chicken, that he cannot do his work because of what we're doing. When there was need for us to ensure that there was compliance with the 2/3 gender rule, we didn't go protesting. We petitioned the Chief Justice to advise the dissolution of Parliament. When there was an attempt to close down the courts because of the COVID pandemic, we called for a meeting and put up what we have right now as the online filing and hearing system. And if there is anybody who did not see what we did when we served, who did not see what transpired when we served, then that problem is one of a hearing problem and a seeing problem. Now that I'm not on trial right now, it is incumbent upon the people who are in office to work. And who are the people in office right now? The person in charge of the judiciary is the Chief Justice. Compare her to what her predecessors did. And Latif will emphasize this until it is heard, because there are many in the office. There are many who are charged with the responsibility of decision making, who have a hearing and seeing problem. You cannot fight corruption by increasing the number of corruption by 25 in the High Court. You cannot fight corruption by increasing the number of corruption in the Court of Appeal by 11. You cannot fight corruption by giving those we accuse of corruption vehicles to move from point A to B. It is as simple as that.
But I'm also hearing you say you cannot fight corruption by taking the route that Nelson Havi took, which is take a petition, let a due process be followed.
No, I didn't say that. That is the route that must be followed. But Nelson Havi is not going to pursue that route because I'm now an old man. I fought these wars. Those who have come before me must take the rifle, must take the pistol and go to war. All generals like Nelson Havi will not go to war.
But you say that is
but
the route
will advise the soldiers who are in combat right now to go to war, and will give them manuscript on how we went to war.
But you say that is the route to follow.
Absolutely.
Then why are you faulting the Judicial Service Commission?
Latif, listen.
Why are you faulting the Chief Justice? If that is the route to follow, it is being followed.
Yes.
The Judicial Service Commission came out last week with a statement and said, we have actually, through this route, received this number of applications. We have processed them. This number of processed applications have gone through. A judge has been removed from office. Why are you faulting that?
We're faulting it because it is not sufficient. It's not satisfactory. And it must be done. And
satisfactory to whom?
To us. We are the consumers of justice. We go to court on your behalf. We do not go to court on our own. We represent the interests of clients, the general public. And when we speak, and I'm afraid, though not so much afraid, that a communique may be issued from the office of the Chief Justice this evening, barring me from appearing before the Supreme Court, because we're speaking about these matters. And we must be allowed to speak about these matters. And it doesn't matter how much vehemence there shall be from the office of the Chief Justice. We, as the people, we, as the advocates who are keen on ensuring that we have independence and accountability from the judiciary, will speak.
You know, Nelson.
And when they make these unlawful, erroneous, unconstitutional decisions like the one she made the other day, we will fight.
Okay.
Because it's not the first time she's doing this. I told you of a previous attempt by 7 judges of the Court of Appeal to muzzle then prominent journalist Tony Gashoka from speaking about corruption in the Golden Bug then. And we saw how it went. We saw how Justice Murugi Mugo attempted to stop an advocate from speaking the truth. And we saw how it went. And if they don't see this, and let me tell you this, I have considerable doubt on whether this so-called order of the Supreme Court was made by the 7 judges. I believe it was not made by the 7 judges. It's most likely have been made by the Chief Justice and a direction given to the registrar of the Supreme Court to communicate it. Where is the decision signed by the 7 judges? So this impunity that we are experiencing now, the dictatorship of an individual in the judiciary, must never be allowed.
You remember, there's due process.
Yes, there's
Here,
due
it's
process.
not the office of the Chief Justice that you have an issue with. It's the person,
But Eric,
the current occupant.
Eric,
There's
if you,
due process. Can you file an appeal to remove the Chief Justice?
Eric, if you listen to this process,
Yeah.
I mean, what Nelson Havi has a right to say what he is saying.
Yes.
Yes.
He has a right to share his opinion publicly. But don't you get the impression that within the legal fraternity, I'm talking about the entire judicial system plus
Advocates.
human rights defenders like Nelson Havi here and others, that there is a clear division. There are those who support a certain way of doing things, and there are those who don't. There are those who believe things should work in a certain way, and there are those who think otherwise. And we are seeing this conflict now. Because, yes, I expect that judges would collate together and protect each other. People do that. If you attack a journalist, woe betide you. We will think about whether that person is in the wrong later. But,
Yeah. Lawyers do that.
All
Case
the
in
time,
point
yeah.
today.
Precisely. You've understood exactly where I'm going with this. And I'm simply saying this. The Chief Justice, how long has she been on this job?
Almost 2 years.
2 years now.
Almost 2 years. Almost 2 years. Remember, Mutunga, who is heralded as a wonderful Chief Justice, also presided over an election, and that didn't go very well for him. Our elections have this tendency of doing damage to people who are office holders in the Supreme Court. It takes you time to recover from it. But is this not then, in my opinion, the test of our system? Meaning, you can actually see the wheels of justice turning. Nelson Havi can come here and say the things he's saying.
Yeah.
And we can actually see visibly in 3D the rebuttal and the fight that he receives. And indeed, we also see how it is that when a judge seems to have been taken to that very, very, very precinct of where it is that they are judged, you get the impression that every effort is made to ensure that they stay. And yet, unless there's something overwhelming or somebody has evidence that you cannot run away from, that we have issues and that we're talking about them is the best thing that could happen to the judicial system. That there are issues that we can point fingers at and say this isn't right and this ought to be checked and this ought to be changed. That is a good thing for our country. If we were not having this discussion, then I would say a terrible thing is happening. But Nelson, tell me one thing. This is the thing I always find puzzling.
Yes.
Whenever people talk about corruption in the judiciary, I don't see anybody bringing the evidence. The only person who has been accused of corruption is the immediate former judge of the High Court, one Mr. Chitembwe. That's the guy who went through this process and was determined this guy should perhaps go and do other things. But beyond that, the noise about corruption is huge. It can't be represented with the removal of just one judge. What about the others? Because it can't be this one person was the only person who was corrupt. Corruption in the judiciary means there are many of them.
Okay.
Why don't we hear these cases being taken forward?
Okay, fine. Let me answer your question sequentially. Self-preservation of professionals. You've alluded to the fact that judges will come and
Yes.
protect themselves.
Oh, they will.
Lawyers will come and protect themselves.
Oh, they will.
Let me debunk you of this false construct first. We have the Advocates Disciplinary Tribunal. Go there. Every week when that tribunal sits, it takes disciplinary action against advocates. And we're very affirmative. We will strike you off the roll. We will suspend you. We'll issue a fine. And the records are there. So the self-preservation in the legal fraternity.
Can I ask a question just there? What percentage of complaints that you receive at the LSK ends up with disciplinary action? Striking off the roll of advocates?
Many.
What percent?
Many.
90%? 100%?
I don't have the statistics.
60%?
I don't have the statistics.
So your
right
own
now.
estimation, is
Yeah.
it more than 50% of our complaints?
No, I'm a mathematician. I don't give figures that I don't have.
Mathematics
but I
also
can give
allows
you-
for approximation.
Well, we'll put it at about 20%.
Okay.
Yeah, 20%.
So 80% are not removed from office.
80%
Are not sanctioned.
And remember, it depends with what the request is for disciplinary action. There are certain conduct that may require striking off the roll. There's certain conduct that will require suspension. There's certain conduct that will require the imposition of a fine. And all these are taken. But if you look at the general statistics, it's only about 20% that will be liable to striking off the roll.
Okay.
But let's progress this discussion.
Yeah.
Elder, the reason as why you're not seeing the evidence of these allegations or of corruption is because that evidence is concealed. Complaints are forwarded to the Judicial Service Commission, and you cannot be able to see progress unless and until the Judicial Service Commission takes action. And the answer has often been this: we will not interfere with the decisional independence of a judge. You understand? A judge will make a decision barring an advocate from appearing before a court without any legal foundation, without any case before that judge, without hearing that judge. And then when we take this complaint to the Judicial Service Commission, we'll be told that is decisional independence of the judge. Therein lies the problem. It is concealed. It will never be seen. And moving forward, there must be publicity. Publicity is the hallmark of fidelity. Let advocates speak. And if a judge feels aggrieved because of the pronouncement of an advocate which borders on defamation, let them go to court and sue for libel or slander. And we've seen this before. Richard Kloba attempted suing Ochieng Oduol with catastrophic results because the evidence of that came forth was overwhelming. And I can tell you, as day succeeds night, if any of these judges decide to sue Ahmed Nasir Abdullahi for defamation, the evidence that will be placed before the court will even scare a dog.
I want to ask you, because there's certain things you talked about the capabilities and competencies of previous individuals who sat in the position of Chief Justice, who sat in positions of the Judicial Service Commission, and what they could or could not do, people who understood their work. Yes. Can you divide the position of Chief Justice or separate the position of Chief Justice from the individual who sits in that position? Because it sounds as though what you've been saying is that there's a competency question or there's a comprehension issue about what this person in this position ought to be doing, and that if they understood it, a visit like what we saw yesterday would not have taken place, number one. Number two, we would have been seeing robust action when it came to fighting some of these matters that we speak of. So are you speaking to the competency and the comprehension of this individual, or do you just not like them?
Now, history will give you Neville Chamberlain as a prime minister who will find it appropriate to go and have an appeasement policy instead of taking decisive action. The same history will give you Sir Winston Churchill, who will adopt a different approach of handling this matter. So the seat will always be there. But often the person who occupies the seat will give it gravitas. I don't have a problem with that. You see, if we didn't have fools, we wouldn't be able to identify who a wise man is. That is the unfortunate nature of history. We'll always have this balance. But because we live in a democratic space, the people must always be alert, to the extent that irrespective of who the person is in that office, the dignity of that office, the power of that office is never belittled. It is the office.
What would have happened that would then have convinced anybody who has a divergent opinion that then the Chief Justice was doing what she ought to do yesterday? She did not accept the visit, suggest the visit, which you said was a terrible mistake. What should have or would have happened that would have convinced anybody of a differing opinion that she actually was taking these matters seriously? When you say those three words, corruption in four words in the judiciary, that is a serious thing. What would have convinced anybody that she was taking it seriously if the visit showed that she was not?
Two things. First, she doesn't need to be prompted to act. She needs to act as a matter of course. So the mere fact that there's been prompting in two aspects. One was the justified lamentation by the president, and two, the complaint by many of us in the legal fraternity, highlighted by Ahmed Nasir Abdullahi, that corruption must be dealt with. So starting from that premise, that was wrong. And the knee-jerk reaction does not yield any visible result. Why can't you take seriously the complaints that are before the Judicial Service Commission instead of instilling fear amongst those who are vested with the responsibility of forwarding complaints to you? Look at it this way. You've barred an advocate from appearing before the Supreme Court because he's talked about corruption. An advocate, not just any other advocate. You understand? This is not just any other advocate. He's been president of the Law Society. He's been a representative of the Law Society of the Judicial Service Commission. He's somebody who knows what he's talking about. You've barred him from speaking. Who else will speak? Therein lies the problem. And the timing here is horrible. It's horrible. There is no defense to the action by the Chief
Horrible
Justice.
for whom, Havi?
It's horrible for you and I, for the people of Kenya.
Why?
Because you, Elder Muga, if you dare make a complaint against a judge, a magistrate, what will happen to you? They're most likely to jail you.
They're most likely to bar me from appearing before the Supreme Court.
No, you don't appear there, so they'll just jail you. Yeah.
My point exactly. You see, please explain to me. You had a problem with a judge. You took legal steps. The president talks about corruption. He, more than anybody else, must have evidence. Why don't we see these matters going before court? Or are we saying...
Why isn't he taking them?
Yes. And why isn't Ahmed Nasir doing the same thing? I mean, unless you're saying that these judges are so corrupt that if we take these cases to court, nothing will happen. Is that what we're saying?
That's exactly what we are saying. We are saying we don't have faith in the Judicial Service Commission to entertain this matter. And we speak from a point of information.
Nelson.
They have not done it in the manner they are required to do it.
Nelson.
And
the Judicial Service Commission says 72 complaints were filed before it in 2023. In the 12 months of 2023. 49 are still undergoing evaluation. 23, therefore,
yes,
they've finished evaluation. 13 were dismissed. 6 of those judges have been asked to respond. 4 have been committed to hearing. Of the 4, 3 judges opted to leave the service, judiciary. 1 went through tribunal, 1 left office. What more would you have done?
Much more. Much more.
By committing all of them?
No, not like committing all of them.
Out of the 23 completed cases, 6 have been asked to respond. That's close to 25%.
That's clearly more than what the law societies, disciplinary committee have been able to actually deal with effectively.
Anyway, Nelson, we are coming to the end of the hour. Please respond in 30 seconds.
We want action. We want to rid the judiciary of corruption and incompetence. And corruption does not necessarily entails the receiving of money. Corruption also is involved when a judicial officer is supposed to be at work and he or she is not at work. When a judicial officer is giving you debts 6 or 12 months away from now. When a judicial officer is not giving you a fair hearing. When a judicial officer is giving you a decision that's not reasoned. That is corruption, that is incompetence. The Chief Justice must listen to the calls of the consumers of justice and ensure that this goal is attained. With that, we'll be able to have a good judiciary. Thank you so much.
This is the Situation Room, the only way to start your day.